Court in Ottawa is hearing a legal challenge by Ontario Premier Doug Ford and Sylvia Jones, who are fighting a summons to appear at the inquiry. With me now is legal analyst Ari Goldkind. Ari, good morning. So, an application citing parliamentary privilege was filed by lawyers for Ford and Jones, this to avoid testifying. Explain today how this is going to work, what the judge is looking at.
Sure, it's really interesting. And when people hear the terms parliamentary privilege, Marcia, or it's a 250-page written application and response, people's eyes glaze over. But the issues are really, really fascinating. By the sheer black letter of the law, parliamentary privilege basically says, look, Doug Ford and Sylvia Jones, the former Solicitor General, as she then was, they're supposed to be in the legislature. They're supposed to be doing the business of Ontarians. They can't be dragged out to all these different things and places and courts and tribunals because it takes away from the orderly work of the legislature. That's the policy rationale. So Doug Ford is basically saying, look, that's what it says. But when you look at the purpose, when you look at the policy behind parliamentary privilege, it's a little bit different than we think of in Ottawa, where you don't get sued for something you say in the House. Doug Ford is essentially making a political calculation cloaked in a legal argument that says as follows. I see what's happening at that Emergencies Act inquiry, even though I bombastically said, and this is important, Marcia, I bombastically said, I'm shoulder to shoulder with the Prime Minister. I will be there if they ask me to come. I support the invocation of the act. Now that I see that cross-examination isn't going so well for people who aren't used to being cross-examined, I'm going to trot out this parliamentary privilege argument, which may succeed on the black letter of the law. But I think in a federal court, a judge may push back on this a little bit. And here's why. If Doug Ford had remained silent and not said anything about how the sausage is made, not said anything about his views and use of the act, not said anything about being willing to testify, that's one thing. But when you say all those things publicly, but then you say, I'll be detracted from my work at Queen's Park for question periods he often misses, I'm not so sure a judge in Ottawa at the federal court level for a federal Emergencies Act inquiry that was mandated by law that has various people testifying from various levels of government. If a judge says it's absolute and we're not going to look into it, that'll be the ruling. But I have a feeling there are some very juicy legal issues for a judge to think about today.
Okay, so how long will it take for the judge to make a decision? And if it doesn't go Ford and Jones' way, can they then challenge that?
So I'm glad you asked that for most people watching this, when we talk about high profile trials that aren't jury verdicts, judges tend to reserve. They may take a month or two because they know they're going to write something that may be subject to appeal from a lawyer like me or many other lawyers. So they're careful. They take their time. They write 50 pages. It takes a couple months. Your question is so wise, Marcia, because if the judge does that here, it's playing into the delay tactic that Ford is counting on here. There's a part of his legal strategy. I haven't spoken to him, but it's a very clever legal strategy that says, look, if the judge reserves and takes a month or two to release a decision, I'll have run out the clock, which will save my posterior from being cross-examined. So the judge at the federal court level today has to know, and they know, there's no doubt that they know this, that they better release a decision in the next few days or into next week on the issues, on the merits. If the parliamentary privilege argument doesn't work, Doug Ford, again, he's no stranger to going to the Supreme Court about this very issue, about cabinet letters. That's literally what he goes to the Supreme Court about, to keep those things quiet. I would expect him to look for some further recourse, but it will send a really strong message that as the head of the government, the federal court may not be as willing to give this parliamentary privilege as much leeway as it has in the past. There are some really critical issues here for accountability and what it means for a head of government who says, look, Marcia, this is a federal inquiry. I'm just a provincial guy. But as you well know and have covered, he has sent provincial people there. He has sent deputies and minions. He's simply saying, I don't want me or Sylvia Jones to be in the hot seat. And I'm not so sure that's the strongest parliamentary privilege argument I've ever heard.
We should also point out the judge is on the clock. I mean, the inquiry is supposed to wrap up in February, so doesn't
That's why your question was so good, Marcia, because so much of this is hoping to run out that clock. I'm not sure that will work. This judge will, I think, have a decision pretty lickety split.
All right. Ari Goldkind, great to have you with us today.